Welcome back to Hashtag Lawyered, everyone. I have a treat for you today. One of my best friends, who's also an assistant DA and who also is the mother to the cutest little girl on the planet, is here with us live. I mean, sort of, kind of like via Skype. But anyway, in studio. Buckle up. We're going to have some fun debates between her and Austin. Welcome back to Hashtag Lawyered, everyone. You have Austin and Andrea and our guest Tara Avants, who's an assistant DA, live and Skyping into studio. So Tara, we're so excited to have you today. Why don't you introduce yourself, everyone?
Well, I'm Tara. I'm an assistant district attorney currently in McLennon County, Texas, in Waco. I graduated from Baylor Law School, where I met Andrea. And yeah, I've been prosecuting for 4 years now.
4 years, wow. So right out of law school, right?
Yes, that was my first job that I took out of law school, and I've enjoyed it and stuck with it and plan to stick with it for a long time.
Yeah, and Tara, I know, doing prosecutorial work, you've got to have a certain motivation to want to do that. What drew you to that line of work?
Well, I think it's a couple different things. One, I majored in psychology in undergrad, and I love talking with people, understanding people, and I felt like being a prosecutor and dealing with crime victims would be a great way for me to do that. And I have been able to do that, and I really enjoy meeting with the victims. And then also, I love being in the courtroom. And as a prosecutor, we do get to be in the courtroom a lot, probably not as much as people think, according to the TV shows, but we do get to be in the courtroom a lot and do a lot of trials, which will start back up soon, hopefully.
Hopefully. I'm with you on that.
Fingers crossed, right? So you mentioned the TV shows. Let's dig into that, because everyone thinks that being a lawyer is like Suits or being a prosecutor is like Law and Order. So why don't you take us, what is the day-to-day and what are like the main differences from TV law?
Yeah, my mom actually has these same questions because she loves those type of shows. I think a lot of people don't realize how much time we actually spend in our office. So we screen our cases for intake, deciding what cases to file, what cases not to file. We spend time in our office preparing for court, whether that's just a status hearing or a trial, a pretrial hearing. We do research in our office. We meet with victims in our office. We'll meet with officers to prep for those hearings in our office. But we do go in the courtroom a lot too. And so we have different dockets. So several days a week, I'll go to court, and we'll either have cases where we've agreed upon a plea agreement. So we've agreed upon punishment and the court has to approve that. Or we'll have various hearings or things like that we have to go to court for.
Yeah, and Tara, I think one of the biggest things that I noticed when I started practicing law, especially on the criminal defense side, working with prosecutors such as yourself, and a lot of people don't understand this, is that, especially in our state system, it's a lot more informal in some of the proceedings and some of the interactions between the judge and the prosecutor and the defense lawyer than people would think, right?
It can be, yes. I think, when you work with the judge and the defense attorneys on a weekly basis, they become kind of your coworkers. And so, we'll talk about what'd you do this weekend before the plea agreement. And it's not that we're not taking it seriously, what we're about to do. It's just, we do this multiple times a week. So I think, there is probably a little bit of informality that's different than what you would see on TV, for sure.
Right, absolutely. Well, and I think too, not to belabor this point, but we've talked about this before, it seems like a lot of times there's a little bit more of a camaraderie between prosecutors and defense lawyers than even we see on the civil side when you've got civil litigation attorneys against one another. And I think a lot of it probably goes to like what you're saying, Tara, is that we're in and out of the courtroom with y'all on a day-to-day basis, and it's not like in a civil case where you may have a case against this person and then never see them, may never have a case against them again.
Yeah.
So it's just a lot more of a routine interaction, I think, between prosecutors and defense lawyers.
I would say so.
Yeah.
Yeah. I only have one criminal
I would
case.
definitely agree with that. I think, by the nature of our work, we are adversarial, but that doesn't mean it has to be personal. it's like I was saying, you're like coworkers. You work multiple cases together, just like you were saying, Austin, where you're going to see each other again and again. So it's important to maintain, positive, healthy relationship with your defense attorney while still doing your job.
Right.
So I'm going to completely pivot and switch subjects here. I know something that you have been really passionate about is the very, very big problem of violence against women. And so what I want to talk about is what are 3 of the biggest issues that show up when they're within this category? And can you explain them to the audience, and what are the 3 things that people need to know about each of these areas?
Yeah, so I think with family violence cases, a lot of what we do relies on what the officer did at the scene. So what evidence they collected, who they interviewed, what pictures they took, things like that. I think one big thing with assault cases in general, whether that's assault between 2 males or a girlfriend and a boyfriend in a family violence situation, is that they may have different stories. And even a witness who observed the incident may have a different story. And a lot of time we joke that the truth lies somewhere in the middle. And when a victim experiences trauma like that, sometimes the way that they process the event immediately afterwards, when they're asked to tell what happened, they're not able to convey that in a linear format. I did this, and then I did that, and then I did this. Like, we would expect them to tell us what would make sense to us. They're not able to do that because they're still experiencing that trauma from the incident. And even a witness may have a different perspective than the victim and a different version of events just because they saw it from a different angle. And so I think you can compare that to like a car accident case where you may have a bystander on the sidewalk that says a different version than the driver of their car, and they may not be wrong. It just may be different based on their different perspectives.
So I want to clear something up a little bit about misdemeanor assault. So with all of these platforms on social media, like Clubhouse, that's like the really big offender right now, or even just like Instagram stories or Reels, people who are not lawyers love to get on and say, like,
Right.
This is the law. Let me tell you what the law is. And I was like, that's great. You're not even a lawyer. So I'm so glad you feel the need to give us legal advice. So misdemeanor assault, can you explain what that is? Because people think it's this big thing where you have to like take a gun and you like pistol whip someone or shoot them. Can you clear that up for us?
Yeah, so there's 2 types of misdemeanor assaults. The first I'll talk about is a Class A misdemeanor assault, which is the highest level misdemeanor, and that is intentionally, knowingly, or recklessly causing bodily injury. And bodily injury is defined as pain is the most common way that we define it. It can also be physical illness or some type of mild impairment. But pain is, anything that can make you say, ouch. And so there may not be a visible injury. For example, if a defendant assaults a victim by pulling her hair, that would hurt and would probably make her say, ouch, but you may not have visible injuries like a black eye or something like that. And then the other type of misdemeanor assault is a Class C assault, which is harmful or offensive touching. And so that's any type of unwanted, we're not talking about sexual contact touching, but just, pushing you in the shoulder, and maybe it didn't hurt, but you were like offended by it.
So, if you have Joe and Joe's like 20 million vodka shots in and he's like in the line to the club and he's like, oh man, like this line sucks. And he like shoves a bunch of people and then like, pulls the bouncer's ponytail. Is he in trouble?
Yes, yeah, he would be. And, voluntary intoxication is not a defense to assault. And so, even if he's drunk and committing this offense, if he pulled that ponytail and that hurt the bouncer, then that could be considered an assault.
Yeah, and one thing I've seen too that I think we as lawyers understand why it happens, but maybe to bystanders it seems a little strange. But when you see a lot of police videos, whether it's body cam or even just reading the reports, many times because of the causing pain element of the Class A misdemeanor, they'll ask the complaining witness or the victim, did that hurt? Did you feel pain? And sometimes just kind of in normal conversation, you think, well, yeah, he punched me in the face. Of course I felt pain.
Yeah.
But I mean, Tara, that's what they're getting at, is they're trying to make sure you have what you need to go forth and tell the jury, yes, it did cause pain. It did meet this element, right?
Yes. And, the officer's standard at the scene is probable cause. But then if we have a trial, we have the burden to prove that beyond a reasonable doubt. And so we have to rely on either the victim testifying that, yes, it caused pain, or by circumstantial evidence, by photographs, which is where the visible injuries would come in.
Yeah. And I don't want to go too far off on a tangent here, but I do, since we have you here and you're the first prosecutor we've had on the show, can you explain to our viewers what you define as beyond a reasonable doubt? I know we deal with this in jury selection all the time, but I think it's a phrase that gets thrown around all the time, and there's not exactly, I mean, some people don't fully understand what that phrase means.
Yeah, again, Clubhouse wannabe lawyers trying to explain what it means when they're not lawyers.
We got the real deal here now.
I know, we've got the real deal.
Yeah, that's a great question. And that's actually something that I ask in every voir dire or jury selection that I do, because there's no set definition of beyond a reasonable doubt. The courts have essentially refused to define it because it's up to each individual juror in a case. But what we like to do in voir dire is to show a picture with puzzle pieces. And the puzzle pieces are in a square, and so you have the majority of the pieces, but not all of them. And so when you look at this picture, you can tell that it's showing a gun, even though there's some pieces missing. And then we'll show, a second picture with all the pieces there. And we'll say, well, in that first picture, even though there were some pieces missing, you could still tell that it was a gun. And so in our case, even though you may not have every single piece that you want, I may not have asked every question that you wanted to hear, but do you have enough evidence to know what happened? Can you see the picture of what is there? And so that's just kind of an example of how we try to convey that to the jurors.
I love that illustration.
Yeah, no, it's great. I mean, it's perfect because it's rarely you're never going to have every single piece in a case.
Absolutely.
That's another thing TV kind of leaves out, is that
right.
There's stuff that's going to be missing in every single case.
And speaking of guns, I want to turn this around to the question of deadly weapons, because I think that's another thing that gets misconstrued a lot, is what are deadly weapons? Because I'm guessing it's more than just a gun.
Yes, so deadly weapon, and I may not get this verbatim, but it's something that's used or capable of being used to cause serious bodily injury. And serious bodily injury has its own specific legal definition and has been interpreted by case law too, but it can be a lot of different things. Serious bodily injury, can be someone who was beat up very badly, or someone that has a specific impairment that's going to last forever, like if they have a broken orbital socket, if their arm is damaged to the point where it's not functioning anymore, things like that. And a lot of different things have been proven to be deadly weapons. So the classic example is a gun or a firearm, but other things like someone's hands have been proven to be a deadly weapon when they caused serious bodily injury to the victim, like broken her orbital socket by punching her in the face so hard. And we've had things like, I think there was a recent case that came out where a drill was covered in a bag, and that was considered to be a deadly weapon because of the way that it was used in the commission of the offense.
And I think the hands part, that's something I've, in kind of debating jokingly with some people about, well, can an MMA fighter's hands be considered a deadly weapon? And that's, everybody wants to jump to that example. But Tara, I mean, what you were saying, and I know what you're talking about, it sounds like, just a normal human being who's not a trained fighter, their hands can still qualify as that.
Yes, and I think in the MMA stuff, there's probably a level of consent that's at play there, whereas if it's just, someone outside who's not wanting to be punched in the face, that would be different.
Right.
And that's where, we have alleged hands as a deadly weapon.
Yeah.
So you could just be, Joe Schmo on the street and, get drunk and punch your girlfriend, break her orbital socket, and that could still be a deadly weapon. You don't have to be like Muhammad Ali to have your hands qualify as deadly weapons, right? Right.
And specifically too in strangulation cases, we've alleged deadly weapon with the hands.
And speaking of strangulation, I'm really glad that you brought that up, because I want you to talk about the development of the strangulation line of cases, because this is something I actually didn't know a lot about until I spoke with Tara on the pre-show conference call. So, Tara, can you kind of tell us a little bit more about this?
Yeah, so I think strangulation cases have traditionally been very difficult to prove because when someone is strangled, there's not necessarily going to be visible injuries. And the way that the injury is caused by the defendant, the victim may not fully feel the effects of the injury at the time. And so that's made these cases difficult. There has been she's now a former prosecutor, but her name is Kelsey McKay, that started a nonprofit organization called Respond. And she actually is speaking in Dallas in May at the Conference on Crimes Against Women and doing a 2-day strangulation series. And she's really led the movement to prosecute these cases and to collect more evidence at the scene. And she created a strangulation supplement that the officers can fill out at the scene with the victim to ask questions about sensations that they felt. And so while there's no visible injuries, if the victim is able to describe, I saw stars, or we had one victim where she said it looked like when the TV goes out and it's like the white and black little dots everywhere. And just the sensations that they feel, Kelsey has analyzed those across multiple cases, and we've been able to kind of pinpoint what are some common ones that pop up in these types of cases. And so I think that's led to more successful prosecutions.
Yeah, and I think from a layman's standpoint, at least, and I don't remember the science behind it or the numbers and everything, but I did see a study one time discussing strangulation and talking about how little amount of pressure it takes to actually cause some of that pain and some of those potentially, we're going to talk about in a second, lasting injuries. And that, to me, makes a lot more sense why we need things like this to make sure that we're understanding whether or not it occurred. I mean, Tara, you know what I'm talking about, that it really didn't take a whole lot of pressure to actually impede someone's breathway?
Yes, you're exactly right. I don't remember the exact number of seconds, but it's less than a minute before it can cause permanent damage to the brain.
That is wild.
Yeah, and that's part of the reason that if someone assaults somebody by strangulation, usually, the way I've seen it, usually you end up with an assault charge and then you have a second strangulation or impeding breathway charge. Is that typically how y'all charge it, Tara?
Yes, and the courts actually, so I did appeals too, but there's been some cases that have come down that have distinguished strangulation from assault because there's different elements. And just like you were saying, Austin, there's an impeding breath element of strangulation that is different from the elements of just assault specifically. Yeah. And so, yes, it is sometimes common to see both of those charged in a case.
Yeah.
So how common is strangulation really? Because, as I'm sitting here and if I'm pretending to just be, everyday Jessica, I'm like, well, I've never heard of anyone really getting, strangled unless it was some sort of crazy serial killer murder show. And so I don't think Jessica, right, everyday Jessica over here, really understands how prevalent strangulation is and how common it is.
I think specifically in family violence cases, it's more common. I know what you're talking about. Sometimes, see the serial killer shows where that's their method. But from my experience, it's been most common between intimate partners. And I think it's a way of using the power and control dynamics that are involved in family violence cases where it gives the abuser power over the victim by strangling them. And a lot of times that is a precursor to murder. And that's one thing Kelsey McKay has looked at, who I mentioned earlier, is that the reason why we need to be prosecuting these cases is because a lot of times when you go back and you look at the criminal history of someone who has committed homicide, there's a strangulation charge somewhere in there. And so it can be a predictor of future, fatal violence.
So what would your advice be to Jessica if her boyfriend gets drunk one night and tries to strangle her?
My advice would be to call for help. I know that's not always the victim's first inclination. A lot of times there's this idea that it needs to stay within the home, or maybe the victim is embarrassed that this happened to her. And I know it could be a him or her. I'm just using a female term for the victim. But my advice would be to call the police or go to a women's shelter or seek help because there are people out there who want to help her and who can help her get out of that situation.
Well, and I'll jump in here. I know we're going to talk a little bit on the defense versus state side about these types of issues, but just so everybody understands too, defense lawyers, we're not fans of family violence. We're not fans of people, committing crimes. We're there to defend them. But one of the biggest things that I would say, and Tara, I'm assuming you'll probably agree with me on this, but they need to call the police as soon as this stuff starts happening, because if you let it go on, sometimes, and whether this is fair or not, it gets used against the victim in court. So not only is it a safety concern, but also to make sure that whoever these people are that are doing these things get what they deserve in the end.
Yes, I think that is a common defense tactic. And, the statistics say that it takes a victim of family violence 7 times to finally leave. And so that's leaving and coming back 7 different times before they're finally able to escape the situation. Some of those times are reported, sometimes they're not. A lot of times when we get a case, it's the tip of the iceberg in that family violence situation. And even then the victim may recant their testimony, or, say, oh, I don't want him prosecuted, please, we're going to get back together. But I think that it's still important to take each of those cases seriously, whether it's the first time they actually report it or they've reported it 4 times before and just maybe the police didn't make an arrest.
So speaking of family violence cases and eventually the topic of drug DWIs, I'm going to let you and Austin start debating this out over the course of 5 minutes. So let's start with family violence cases. And I'm going to let Tara take it away first, since she's the prosecutor.
Well, and Tara, I don't know if there's a specific subject that you tend to like to key in on that. There's different viewpoints on a lot of different things that go into family violence.
I think one thing that I've found interesting in some of my cases that I've tried, which the majority of my trial experience has been family violence, is that the defendant likes to testify in those types of cases, and his story often is similar to the facts and to the victim, but just with certain things left out. Like, he will leave out that he hit her, but he'll tell everything else the same.
Yeah. Well, and I think a lot of that goes into, you talked about the different perspectives that are there with a family violence case. You've got the victim, you've got the bystander, you've got the alleged defendant, the assailant there. I think in the cases I've tried, it's been kind of a mixed bag. I think anytime that you've got self-defense, you've got to put your defendant on the stand, because if you're claiming self-defense, you've got to tell your story. And there's always exceptions to the rule. But the problem is you open somebody up to cross-examination whenever you put them on the stand, and it's a lot harder for them to, defend themselves. Tara, one thing I'd like to talk about is the training that goes into the family violence training that goes into the officers that are on patrol that go out and actually investigate these cases. I think for me, that's one of the biggest shortfalls I see just in my work on the defense side is, and tell me if I'm saying this right, but in a lot of counties, there's a policy that if the officer believes that family violence occurred, then he or she has to arrest somebody on the scene. And it sounds silly because probable cause gives you the right to arrest anyways, but I believe this policy was put in place because of witnesses recanting or victims recanting. Do y'all have a policy like that in McLennon County?
Yeah, I think I know what you're talking about, and I think it's actually a statute that was passed by the legislature that really kind of tightened up investigations on family violence cases where officers are, out there at the scene. And I think traditionally some officers may have just said, well, why don't you guys just split up for the night and then it'll be okay. Let's just get you separated and everything will cool down. It'll be fine. Whereas now with the new law that's come into play, it's okay. You know what? We need to make an arrest because something did happen here. We have probable cause and, somebody's got to go to jail. I do hear what you're saying about sometimes there has not been as much training on family violence. I worked really hard in my work in Limestone County to set up more trainings for our officers because for a lot of them, it's not a natural thing to talk to victims at the scene and try to understand the trauma they've just been through and be empathetic to them. And so, maybe sometimes they're used to working the drug cases where it's more cut and dry. We do the stop, we do the search, we find the drugs.
Right.
And family violence cases get messy because there's emotions, there's love, and things like that. So I think that just makes it more difficult. But hopefully, there's more trainings being put in place now for officers so that they can get a better understanding of what to expect when they go to those hot calls.
Yeah, no, and I agree. And I think part of my issue, and this is more of a broad issue, but specific to family violence, is I've been in a lot of cases where, in my opinion, an arrest never should have been made. There should have been more investigation on the scene. And then eventually we either got an acquittal or we got a dismissal. And so it worked out, but not until the client paid thousands of dollars and went through a year and a half of dealing with what they had to deal with and everything. From that case, there really was no oversight or additional training required for the officer because the arrest shouldn't have been made. So kind of one of my issues is I feel like I love that, like you talked about in Limestone, you guys are doing more training. I feel like there needs to be some type of oversight for those types of mistakes that get made on the scene to get rectified. And I don't mean sanctions or anything like that, but more training or something like that. What do you think about those issues?
Yeah, I think more training is always going to be beneficial to the officers. And a lot of times officers are brand new who are out on patrol. The experienced officers promote to be investigators and more, in an administrative position at the agencies. And so the people that you have out on the field in the middle of the night when these cases are happening are oftentimes brand new. And so there has to be an element of them learning how to do their job. And just like any of us, doing our jobs, we're going to make some mistakes. And so, when that happens, hopefully there's a prosecutor that can screen that case and say, okay, this is not one that needs to be filed and not one that needs to be prosecuted.
So one of the topics that you were talking about, drug DWIs,
Yes.
I think that probably the most common one that most people are really curious about is when it comes to marijuana.
Yeah.
Whether you've got weed in your system or not.
Driving while high.
Yeah. Tara, just before we talk about this briefly, can you explain how you guys typically prosecute or charge these cases if you've got somebody that's suspected of driving while high under the influence of marijuana specifically?
Yeah, that's definitely a growing trend in DWI cases. And it's difficult in Texas because we don't have a per se limit. Just like with alcohol, you kind of know, okay, they're above a 0.08, they're considered legally intoxicated, but we don't have that with marijuana. So in those types of cases, either the officer would ask for consent to a blood draw, or they would get a search warrant to do a blood draw if they do find the defendant to be, probable cause to find him intoxicated. But even then, it can take months and months to get those lab reports back from the DPS crime labs because they're so busy. And then even when we get those back, depending on the levels in their system, we may or may not be able to show that they had the active psychoactive ingredient of marijuana. Sometimes it's just what's called marijuana metabolite in their system. And so I think that just the difference with drugs is there's a bigger spike, but then it goes down a lot faster. Whereas with alcohol, it's a more gradual decline in the blood.
Right.
So it just makes it more challenging to prosecute.
Yeah, well, and I think, you kind of took the words out of my mouth. I don't know if this is going to be much of a debate because I agree with Tara on this.
Gosh, Austin, come on.
Well, because the problem is that because of the difficulties, because of the lack of scientific studies, that's why I have a problem with how many people get prosecuted for DWI when it comes to marijuana. Mm-hmm. And there's all sorts of political and other viewpoints on how much that drug actually affects you. And there's some science behind it, some science that's kind of about it. But without having that hardline rule there, and without having some type of field sobriety test that actually shows, these types of things, it's hard to really say like, yeah, you know what, we should be prosecuting this. That's just my opinion on that.
So I have a question. Okay, let me just give you this rapid fire hypothetical real fast. Jimmy is driving his Prius. He's had 2 glasses of wine, but he's smoked, I don't know, what's a lot of weed?
Let's just say he's had a couple joints.
Okay, sure, whatever. And then he hits Billy the Kid on his way home from playing Nintendo 64. What's going to happen prosecutorially, and what would you say would be his best defense? So, Tara, prosecutorially, what's going to happen?
Yeah, so, if he has consumed some alcohol, I think they would definitely do the field sobriety test. And even if it was just marijuana, they're probably still going to. We do have drug recognition experts now that are called out to the scene when there's, suspected synergistic effect between drugs and alcohol. And they are highly trained to look at specific things that just maybe an ordinary officer who hasn't had that advanced level of training would have. And so in the bigger counties, they're on call all the time to come out to the scene on those cases. So hopefully we'd get that additional evidence collected at the scene and be able to see, what kind of was going on in this guy's system.
Yeah, and he's probably going to get charged with intoxicated manslaughter, and so defense-wise, you're really going to key in on the DWI elements because there's no doubt that he killed the kid, but you're going to want to try and disprove that. And here's just a pet peeve of mine, and I don't know if you're like this or not, Tara, but DUI in Texas only for minors. Everything else, drugs, alcohol, whatever, is a DWI. There's a lot of states that call it different ways, and that's a stupid pet peeve of mine, but I just want everybody to understand it's a DWI in Texas. That's what you get arrested for as an adult.
Oh, good to know. All right, so Tara, final parting words of wisdom, right? So you're a mother and you've dealt with a lot of family violence cases. You're also a prosecutor. So what is the advice that you would give to Madeline, your daughter, when she's old enough to listen about how to protect herself and keep herself safe in a world where violence against women, it's like a pandemic. It happens so frequently. So what would you tell Madeline and other mothers with daughters?
Yeah, I would just say, you need to know your worth, and love shouldn't hurt. And so even though you're in this situation, you feel like there's no way out and it keeps hurting, that's not a healthy situation to be in. And if you know your worth, you know that you can get out, there's people out there that can help you, that want to help you. And also just being able to maintain some independence even while in a relationship, I think is important. And then whether that's financial independence or just personally feeling confident that you're independent in your own way, and that you're not reliant on someone. Because I think a lot of times people stay in those relationships because they have these ties and they're reliant on this person and they feel like they can't separate.
Tara, thank you so much for coming on today and for those very eloquent words at the end. I had a blast. I'm sure Austin did too, even though he couldn't bring the debate skills up here.
Well, some of these things, like we talked about, prosecutors and defense lawyers sometimes see eye to eye on certain things.
There's a lot of camaraderie. I wasn't expecting that, honestly.
Yeah. Well, but that's also part of trying to achieve justice, is we're both there for the same reasons.
Yeah. So Tara, thank you so much.
Thank you guys so much for having me on. I really appreciate it. This was a lot of fun.
Well, you can come back anytime. All right, take care. Hey y'all, don't go. We have closing arguments coming up for you in just a second. But before you listen, make sure to rate, review, and subscribe to the podcast if you got any value from today's episode. And please share the podcast with others. And if you want to interact with Austin or me or tell us what you want to hear next, you can find me on Instagram at andrea.s.turner, Austin at the Dallas Lawyer spelled out, or the podcast #lawyered spelled out. Look forward to hearing from you.
In the trial of the killer of George Floyd, prosecution witnesses came out on April 6th and testified that Officer Derek Chauvin disregarded his police training when he used the strangle technique on Mr. Floyd. This is a huge piece of evidence that's been hotly debated across the country and now may seal Mr. Chauvin's fate in his trial.